The United Kingdom's invocation of Article 50 of the Treaty on European Union is a major step in the UK withdrawal from the EU. Background: the first likely invocation of Article 50 of the Treaty on European Union will be with the United Kingdom, after the Leave vote in the 2016 referendum on the United Kingdom's membership of the European Union. When David Cameron resigned, he stated that the next Prime Minister should activate Article 50 and begin negotiations with the EU. There is dispute over whether the decision to invoke Article 50 is the prerogative of the government, as the then government argued, or whether it requires parliamentary assent. The Constitution of the United Kingdom is unwritten, and the meaning in UK law of the phrase "its own constitutional requirements" is untested. The law firm Mishcon Rare announced that it had been retained by a group of clients to challenge the constitutionality of invoking Article 50, without Parliament debating it. However, Parliament will be able to vote on any new treaty arrangements that emerge from any withdrawal deal that is reached, though rejecting such a deal would not stop the withdrawal process once Article 50 is activated. Necessity of invoking Article 50. As with all but one UK referendums, it was an advisory referendum and so could theoretically be ignored by Parliament. The exception was the United Kingdom Alternative Vote referendum 2011, which would have become law if there had been a yes vote. However, the Conservative government has committed to invoking Article 50 at some point. Pre-notification negotiations. As long as the UK government has not invoked Article 50, the UK stays a member of the EU, must continue to fulfill all EU-related treaties, including possible future agreements, and should legally be treated as a member. The EU has no framework to exclude the UK, or any member, as long as Article 50 is not invoked, and the UK does not violate EU law. However, if the UK were to breach EU law significantly, there are legal venues to discharge the UK from the EU via Article 7, so-called the nuclear option, which allows the EU to cancel membership of a state that breaches fundamental EU principles, a test that will be hard to pass. Article 7 does not allow forced cancellation of membership, only denial of rights such as free trade, free movement and voting rights. At a meeting of the heads of government of the other states, leaders decided that they will not start any negotiation before the UK formally invokes Article 50. Consequently, President of the European Commission Jean-Claude Juncker ordered all members of the EU Commission not to engage in any kind of contact with UK parties regarding Brexit. Media statements of various kinds still occur. For example, on the 29th of June, European Council President Donald Tusk told the UK that they won't be allowed access to the European single market unless they accept its four freedoms of goods, capital, services, and people. Angela Merkel said, "We'll ensure that negotiations don't take place according to the principle of cherry-picking. It must and will make a noticeable difference whether a country wants to be a member of the family of the European Union or not." Cameron has declared that the next Prime Minister should activate Article 50 and begin negotiations with the EU. Renegotiation of membership terms. There is no established, formal process for holding a second referendum to confirm the decision to leave following negotiations. Alan Renwick of the Constitution Unit of University College London argues that Article 50 negotiations cannot be used to renegotiate the conditions of future membership, and that Article 50 does not provide the legal basis of withdrawing a decision to leave. In April 2016, David Cameron stated that he would expect a leave vote to be followed by withdrawal, not by a second vote. Responsibility for notification. The referendum was not legally binding on the government. Under the principle of parliamentary sovereignty, government and parliament can choose to ignore the result. If the government decides to leave the EU by invoking Article 50 of the Treaty on European Union, it will have to decide when to do so. Withdrawal from the European Union using Article 50 is an untested procedure with some complexity. In a discussion of this topic, The Guardian provided specifics as to the likely method. It is entirely up to the departing member state to trigger Article 50 by issuing formal notification of intention to leave. No one, in Brussels, Berlin or Paris, can force it to. But equally, there is nothing in Article 50 that obliges the EU to start talks, including the informal talks the Brexit leaders want, before formal notification has been made. There is no mechanism to compel a state to withdraw from the European Union, said Kenneth Armstrong, professor of European law at Cambridge University. The notification of Article 50 is a formal act and has to be done by the British government to the European Council, and EU official told Reuters. Timing, as was the case with the Scottish independence referendum 2 years earlier, the 2016 referendum did not directly require the government to do anything in particular. It does not require the government to initiate or even schedule the Article 50 procedure, although David Cameron stated during the campaign that he would invoke Article 50 straight away in the event of a Leave victory. However, following the referendum result, Cameron announced that he would resign before the Conservative Party conference in October, and that it would be for the incoming Prime Minister to invoke Article 50. A negotiation with the European Union will need to begin under a new Prime Minister, and I think it is right that this new Prime Minister takes the decision about when to trigger Article 50 and start the formal and legal process of leaving the EU. Cameron made it clear that his successor as Prime Minister should activate Article 50 and begin negotiations with the EU. Among the candidates for the Conservative Party leadership election, there were disagreements about when this should be. Theresa May said that the UK needs a clear negotiating position before triggering Article 50, and that she would not do so in 2016, while Andrea Leadsom said that she would trigger it as soon as possible. According to EU Economic Affairs Commissioner Pierre Moscovici, Britain must proceed promptly. There needs to be a notification by the country concerned of its intention to leave, hence the request to act quickly. As well, the EU issued a joint statement on the 26th of June 2016 regretting but respecting Britain's decision and asking them to proceed quickly in accordance with Article 50. The statement also added, "We stand ready to launch negotiations swiftly with the United Kingdom regarding the terms and conditions of its withdrawal from the European Union. Until this process of negotiations is over, the United Kingdom remains a member of the European Union, with all the rights and obligations that derive from this, according to the treaties which the United Kingdom has ratified. EU law continues to apply to the full to and in the United Kingdom until it is no longer a member." After a debate about the planned UK exit on the 28th of June 2016, the EU Parliament passed a motion calling for the immediate triggering of Article 50, although there is no mechanism allowing the EU to invoke the article. Possible delayed exit. In the UK, there is a growing consensus that the government should delay invoking Article 50 of the Lisbon Treaty, starting the clock on a maximum 2-year divorce negotiation until early 2017 at the earliest. That is provoking alarm in many European capitals, where there is an equally clear consensus that Article 50 should be invoked as soon as possible, with the next French presidential election being held in April and May 2017, and the next German federal election likely to be held in autumn 2017. 2016. The European Commission is now currently working under the assumption that Article 50 notification may not be made before September 2017. Other bodies. UK Parliament. There is dispute over whether the decision to invoke Article 50 is the prerogative of the government, or whether it requires parliamentary assent. However, Parliament will be able to vote on any new treaty arrangements that emerge from the withdrawal deal, and would have to legislate to repeal the European Communities Act 1972. On 3 July 2016, the law firm Mishcon de Rare announced that it had been retained by a group of clients to challenge the constitutionality of invoking Article 50, without Parliament debating it. It is also unclear to what extent the devolved Northern Ireland Executive, Scottish Government and Welsh Government will have to be involved in the process. Nicola Sturgeon has said that the Scottish Parliament will not give legislative assent to any act to implement withdrawal from the EU. Government lawyers for the group headed by Oliver Letwin have advised that invoking Article 50 is a government prerogative, but that repeal of the European Communities Act by Parliament is a prerequisite and therefore the legislature is de facto involved. On 19 July 2016, at a preliminary High Court hearing of a challenge to the government's claim that it could issue the Article 50 notification without parliamentary approval, lawyers for the government confirmed that the Prime Minister would not issue any such notification before the end of 2016. Nicholas J. Thursley of the World Pensions Council has argued that it could be in Britain's national interest to proceed slowly in the coming months. Her Majesty's government may want to push Brussels to accept the principles of a free trade deal before invoking Article 50, hopefully gaining support from some other member states whose economy is strongly tied to the UK, thus allowing a more nimble union to focus on the free trade of goods and services without undue bureaucratic burdens, modern antitrust law and stronger external borders, leaving the rest to member states. Prime Minister Theresa May confirmed that discussions with the EU would not start in 2016. I want to work with the European Council in a constructive spirit to make this a sensible and orderly departure, she said. All of us will need time to prepare for these negotiations and the United Kingdom will not invoke Article 50 until our objectives are clear. Quote, in a joint press conference with May on 20 July, Germany's Chancellor Angela Merkel supported the UK's position in this respect. We all have an interest in this matter being carefully prepared, positions being clearly defined and delineated. I think it is absolutely necessary to have a certain time to prepare for that. Scottish Parliament. Some constitutional experts have argued that, under the Scotland Act 1998, the Scottish Parliament has to consent to measures that eliminate EU law's application in Scotland, which gives the Scottish Parliament an effective veto over UK withdrawal from the EU, unless the Scotland Act 1998 is amended by the UK Parliament to reduce the Scottish Parliament's current powers. After the Leave result was announced on 26 June 2016, First Minister Nicola Sturgeon said she, of course, would ask the Scottish Parliament to withhold consent and thus block the UK from leaving the EU. However, this interpretation of the 1998 Act is disputed. For example, Sub-Clause 7 of Clause 28 of the Act states that it does not affect the power of the Parliament of the United Kingdom to make laws for Scotland.